Welcome back kapatid! In this video, I will be discussing under 18 or over 70 years of age as one of the mitigating circumstances enumerated in the revised penal code. The basis of the mitigating circumstance is diminution of intelligence. In lowering the penalty, it is based on the age of the offender at the time of the commission of the crime, not the age when sentence is imposed. In suspension of the sentence in case of minor offender, it is based on the age of the offender at the time the sentence is to be promulgated. Is the mitigating circumstance considered ordinary or privilege? The answer to that question is privilege. The following are the legal effects of the various age brackets of the offender with respect to his criminal liability. If the offender is 15 years of age and under, it is considered exempting circumstance. If the offender is over 15 but under 18 years of age, it is considered exempting circumstance if he acted without discernment. It is considered mitigating circumstance if he acted with discernment. If the offender is 18 to 70 years of age, he has full criminal responsibility. If the offender is over 70 years of age, for purposes of discussion, there is no imposition of death penalty. If already imposed, the execution of death penalty is suspended and commuted. If at the time of sentencing, the accused is still below 18 but over 15 who acted with discernment, the provision of Republic Act No. 9344 will apply. Thus, the sentence shall be suspended and the child shall be placed under the custody and supervision of the SWD. The mitigating circumstance of old age is applied only when the offender was over 70 years at the time of the commission of the offense, not at the time of the promulgation of judgment. That's all for this topic. For our next video, I will be discussing praeter intentionem as a mitigating circumstance. Just comment your questions if there's any and we will try to answer them.